This courtroom hearing starts off like a routine case, but within moments, it becomes clear this is anything but ordinary. The man standing before the judge refuses to accept a simple fact, that he is the defendant in his own criminal case. Claiming sovereign citizen beliefs, he repeatedly insists that he is not the person the court is addressing, even as his name, charges, and record are laid out right in front of him. David Walker is facing serious allegations, including drug possession and driving with a suspended license. But instead of addressing the charges, he challenges the system itself. He questions the court's authority, asks who the real defendant is, and argues that there is no victim, despite the state clearly bringing the case against him. The judge patiently explains how the law works, making it clear that criminal cases do not require an individual victim when the state believes the law has been broken. Things only get more intense when Walker's history comes into focus. He previously failed to appear in court, leading to a $10,000 cash bond. On top of that, he's facing another separate case with yet another bond, all tied to the same pattern of refusing to participate in the legal process. Even after being offered a court-appointed attorney, he insists on representing himself, while simultaneously claiming confusion about his own identity. As the hearing continues, the courtroom becomes a textbook example of how sovereign citizen arguments collide with reality. The judge remains calm, the law remains firm, and the outcome becomes increasingly inevitable. This case serves as a powerful reminder. No matter how often these theories appear online, they carry no weight inside a real courtroom, and the consequences are very real.
And your name, sir?
David Walker.
Your Honor, it looks like he has two files.
I see that. All right, we'll next take up two cases, both entitled State of Kansas versus David Wayne Walker, 22 CR 398 and 22 CR 508. All right, we'll first take up 22 CR 508. This is my case, Mr. Walker. You failed to appear in front of me on July 17th for your preliminary hearing control docket. Where were you that day?
Say for sure, sir.
Okay, well, I issued a bench warrant bond forfeiture and set a new bond in the amount of $10,000 cash or surety. Are you still representing yourself?
Yes, sir.
Do you want to continue representing yourself?
Look at me. I'm not looking at you. I'm looking at the paper. Yes, sir. Don't have any money to.
Pardon?
Yes, I guess I'll represent myself.
Okay, you understand that if you can't afford to hire an attorney, one would be appointed for you.
I don't know what he would do for me.
Okay, well, he could provide you legal advice and perhaps advance any defenses you may have had, but if you want to represent yourself, you have that right. I just want to make sure you understand that if you can't afford an attorney and would like to have one represented you, I would appoint one for you. Do you understand that?
Yes, sir.
And you wish to continue representing yourself?
Yes, sir.
The docket notes don't reflect if a waiver of counsel was ever signed. Do you have any notes that would reflect that he's waived counsel on the record or otherwise, Ms. Norris?
Your Honor, I just note that on December 30th of 2022, defendant stated that he would hire his own counsel, and then he had a failure to appear, and on May 5th, we did not appoint any counsel. I don't show an actual waiver, and the notes don't reflect that he did a waiver on the record. It just says that he would hire his own attorney.
Okay. Well, Mr. Walker, you've indicated here on the record that you wish to waive your right to an attorney and represent yourself. So I'm going to have you, if the jail has one, sign a waiver of counsel. Do you have a form?
I believe so.
All right. Can you read through that? Make sure you understand it. If you have any questions, be sure to ask me.
There
Here.
is no defendant in the, I'm the defendant in the case. Am I the defendant? There's no victim. There's no victim to my crime, correct? The crime that I'm accused of, there is no victim in the crime.
The state of Kansas, you have drug charges, possession of methamphetamine, possession of paraphernalia, and driving while suspended are your 3 charges.
Yeah, but no victim, correct? No victim in the crime? No victim?
I'm not sure I understand your question and what that has to do with your waiver of counsel.
Well, I'm the defendant. There must be someone making a claim that
The state of Kansas is making the charges against you, Mr. Walker.
the state of Kansas is the victim.
The state of Kansas charged you with these crimes. Do you wish to represent yourself or do you wish to have an attorney representing you?
I will represent myself.
You've got a waiver of counsel in front of you, correct?
Yes, I suppose so. Why do I need to sign? Why do I need to sign it? Why do I need to sign this?
Because I like to have it documented in the file that you understand that you have a right to have an attorney representing you, and that if you can't afford to hire one, one would be appointed for you. And you understand that, and knowing those rights, you wish to represent yourself. That just documents that for the court file.
What I don't understand is why there is charges against me when there is no victim.
All right, Mr. Walker, I'm not going to play this game this afternoon. I'm going to set this case
Why are we playing a game
in front of me on.
Trying to understand.
Mr. Walker, your case is being set on October 10th at 2:30 in front of myself, and that will be done by Zoom. That's the felony preliminary hearing control docket, October 10th at 2:30.
Your Honor.
You got a $10,000 cash or surety bond on that case.
Yeah. I was wondering if I wouldn't be able to have access to certain legal things to be able to put my case up.
I believe they've got a law library there at the jail. I'm not sure what kind of access they provide to you, but you can consult with somebody there at the jail.
Okay.
All right, I'm now going to take up 22 CR 398. This is Judge Webster's case. Looks like you failed to appear in front of her on July 31st. She set a new bond for $6,000 cash or surety. You've already had a first appearance, so I'm going to set this in front of Judge Webster on October 30th at 9 o'clock in the morning. That will be by Zoom, October 30th at 9 o'clock in the morning. So again, your bond is $6,000 cash or surety. Anything else on this case, Ms. Norris?
No, Your Honor, thank you.
Your Honor, was the time for court on October 10th for 22 CR 508, was that 2:30?
That's correct.
Just clarifying. Thank you, Your Honor.
All right, we'll be in recess. Mr. Walker, you are.
This courtroom hearing opens with an uneasy stillness, the kind that usually signals something unexpected is about to unfold. From the very first words spoken, it becomes clear that this is not going to be a routine appearance. The man standing before the judge, identified as David Walker, immediately distances himself from the case. He doesn't deny the charges. He doesn't argue the evidence. Instead, he questions the most basic foundation of the hearing itself, his own identity. Walker claims he is not the defendant named in the case, repeatedly asking the court to prove who he is and why he is being addressed. This tactic, commonly associated with sovereign citizen ideology, sets the tone for everything that follows. As the judge calmly attempts to establish basic facts, Walker interrupts with philosophical objections, legal-sounding phrases, and circular questions designed to stall progress rather than resolve anything. The charges against him are serious. He is facing allegations of drug possession and driving with a suspended license, offenses that carry real legal consequences. Yet Walker treats the courtroom less like a place of accountability and more like a debate stage. He insists that without a victim, there can be no crime. He argues that the court has no authority over him as an individual. Each claim is delivered with confidence, as though repetition alone might somehow bend the law in his favor. The judge listens carefully, allowing Walker to speak, but never losing control of the room. When Walker claims there is no injured party, the judge explains that criminal cases are brought by the state, not by private individuals. Laws exist to protect public safety, and when those laws are violated, the state has both the authority and the obligation to act. This explanation, clear and straightforward, is met not with understanding, but with more resistance. Walker continues to press the same points, asking again and again whether he is truly the defendant. Even as his name is read aloud, his case number confirmed, and his charges detailed on the record, he refuses to accept the reality in front of him. The hearing slows to a crawl as the judge is forced to revisit the same ground repeatedly, addressing arguments that have been rejected in courtrooms across the country for decades. As the discussion continues, Walker's legal history begins to surface. The court notes that he previously failed to appear for a scheduled hearing. That failure was not without consequences. A $10,000 cash bond was issued as a result, reflecting both the seriousness of the charges and the court's concern that Walker might again avoid appearing. This wasn't a misunderstanding or a paperwork error, it was a conscious decision not to show up. Even more concerning, this is not the only case pending against him. Walker is also facing a separate matter involving another failure to appear, this time with a $6,000 bond attached. The pattern is unmistakable. Rather than engaging with the legal process, Walker appears to be actively resisting it, hoping that non-participation will somehow undermine the court's authority. Despite all of this, Walker declines the offer of a court-appointed attorney. He insists on representing himself, claiming he understands his rights and the law. Yet moments later, he again expresses confusion about whether he is the defendant. The contradiction is striking. The judge carefully explains that self-representation is a serious decision, one that carries risks. Choosing to act as one's own lawyer does not pause the proceedings, lower the standards, or excuse non-compliance. Walker's responses suggest either a fundamental misunderstanding of the legal system or a deliberate attempt to manipulate it. He speaks in loops, returning to the same phrases and objections no matter how many times they are addressed. The judge, maintaining patience and professionalism, ensures that every explanation is placed clearly on the record. This is not for Walker's benefit alone, but for the integrity of the process itself. At various moments, it becomes difficult to tell whether Walker truly believes what he is saying or whether this performance is strategic. Some observers speculate that such behavior is intended to create confusion, delay proceedings, or lay groundwork for future appeals by claiming ineffective assistance or lack of understanding. Whatever the motivation, the strategy is ineffective. Courts are built to handle resistance, and the law does not crumble under semantic games. The judge reiterates that belief systems, no matter how passionately held, do not override statutes, court rules, or established precedent. Sovereign citizen arguments, while popular in online forums and fringe legal discussions, have no standing in actual courtrooms. Judges across jurisdictions have heard these claims countless times, and the outcomes are always the same. As the hearing continues, the atmosphere grows heavier. Walker's refusal to acknowledge basic legal realities begins to work against him. Each repeated objection is noted. Each refusal to answer directly is documented. The record grows longer, not in Walker's favor, but as evidence of his unwillingness to cooperate with the process designed to ensure fairness. The judge remains calm throughout, never raising their voice, never engaging emotionally. This calmness contrasts sharply with Walker's persistent resistance. It highlights a fundamental truth about the legal system: it does not need to argue back. It simply moves forward. Orders are issued. Bonds are set. Dates are scheduled. The machinery of justice continues, regardless of whether the defendant agrees with it. By the later portion of the hearing, the outcome feels less like a question and more like an inevitability. Walker's arguments have been fully heard, fully addressed, and fully rejected. The court has done its part to explain, to warn, and to offer legal assistance. What remains is Walker's responsibility to face the consequences of his choices. This hearing becomes more than just a single case. It serves as a broader example of what happens when ideology collides with reality. The courtroom is not a forum for testing internet theories. It is a place governed by law, precedent, and procedure. Refusing to acknowledge that does not grant freedom, it removes options. As the judge brings the discussion back to procedural matters, it is clear that the system will proceed with or without Walker's cooperation. Bonds remain in place. Charges remain active. The record stands complete. Whatever Walker hoped to achieve through denial and defiance has failed to materialize. In the end, this case illustrates a hard truth that many defendants learn too late. The law does not recognize personal sovereignty as a shield against accountability. Identity arguments do not erase records. Wordplay does not undo warrants. And belief, no matter how strongly held, does not outweigh evidence, jurisdiction, and legal authority. The courtroom does not bend. It does not argue ideology. It listens, records, decides, and moves forward. And in this hearing, as in so many others like it, that reality becomes impossible to ignore.